bankruptcy foreclosure world, which then led to, thankfully, when the market got healthier, I've been doing more title and real estate closings on buyer side and seller side. And I represent many foreign clients as well. So I started to work on the new contract since about August, when there were rumors or whatnot of the committee and the Lawyers Association starting to submit language for the proposed new contract, which started to be used on November 1st. How you know you're using the right contract is that on the bottom, and it's already on Dotloop and the pre-done forms on the association's websites and for documents and things like that. So you probably don't even have to worry about using the right contract, but just in case, the new contract on the bottom says CR6, and it'll have October 2021 on the bottom, so that you know that you're using the correct contract. I know we're all busy, we're on the road. So what I like to do is, I don't have any PowerPoint presentations. I orally go through what I call the red flag, big ticket items of the contract. I'll even share some examples of real life scenarios that I have experienced myself. And at the end, I can open it up for a brief Q&A. Yes, that's right. The Form Simplicity CR6 is the contract. See it there in the chat. Anyway, so I like to go through it in a very practical, real life scenario, what I've seen happen already since October/November, some of the disputes that are already starting to go to mediation. And just so you know, this is not my own interpretation of the contract. This is something that I worked closely with and I have reviewed, and I still continue to review with FREC and the legal advisors for the Florida Association of Realtors. And just something that I learned last week, I'll be sharing today as well. What I'm going to start with is what I'm going to review today is the as-is contract. Most of us use the residential as-is contract. And with that, right away on the first page, they added something very interesting, and it's interesting. Sarah, I think you're the host. Just mute everybody if you can. Yeah, perfect. Thank you. So we're going to already see in paragraph 2, first page of the contract, talking about personal property. Why is that so important? Well, for you agents who are representing the seller, you're the listing agent. When you're taking on your client, you're going to the listing agreement meeting where you want them to sign the listing agreement with you as the agent. You're going to maybe do a tour of the property, a tour of the inventory they have. What's very important for the seller now is that if the seller wants to exclude any of the personal property from the listing, meaning they can't take it with them on the day of closing, that they're moving out. What they've included here is that the seller must put there any smart home devices, like the Nest, the Ring camera, and any what they call devices or equipment that is used to mount a sound bar, mount a flat screen. And I think you all know what I'm talking about, because I have had many run-ins on the day of closing when there's a walkthrough and the buyer's upset because maybe a bracket was removed from the wall, or maybe they saw some sort of, alarm system or audio device in the doorway, and the buyer thought, well, why did the seller take it? That's a fixture, that's part of the property. Well, to clarify that, paragraph 2, remember, listing agents taking on a seller, look around. If there's any smart devices, add on there. Why is that important? Because when we go to the walkthrough or where we get to closing day and you represent the listing agent and you say, oh no, the buyer, you have to leave the bracket, you have to leave the ring or whatever, they're going to be upset with you because they wanted to take that. They think that's their personal property. So there is where you're going to put in paragraph 2, when it talks about excluded items, if the seller wants to take those devices with him or her, you have to put it in there. So I think that's a very important practical boots on the ground advice, because perhaps maybe that's something that was overlooked in the past or not clarified. So moving on, and again, take some notes if you have any specific questions, and I'll try to address them afterwards. Moving on, closing date. What is the closing date? It's a small revision, but basically the time, the closing date, that is governed by where the subject property is located. So why does that matter? Maybe to some of us, we think, well, that's obvious, wherever the property is. Well, it's not, because especially now in this market, we have people from California, 3-hour difference. We have people from out of the country, and there could be a huge time difference. The time zone, the time of closing, the date of closing is where the property is located. So, that's also very important, because in my opinion, we've already run into that with, effective dates, closing dates, people out of the country. No, we go by the time zone of where the property is located. Sounds silly, but in practical life, those are all very important things. I also wanted to clarify, and I'm very happy about this. What defines a closing? Well, in the 14 years that I've been practicing real estate law, it always came down to the closing date, that the seller was, what I like to say, holding the keys hostage. That means that we have a closing, there's been funding, it's a Friday afternoon, the seller's account doesn't see the funds, and now a buyer has a moving truck, scheduled, all this moving, all these painting plans, all of these plans over the weekend, and the seller and the listing agent are holding the keys hostage, okay? It's a very awkward, tense weekend for me as a title agent, the realtors involved, and it's not pleasant. So I'm super happy that they added this. So this is one of my ding, ding, ding items. Remember this. When the title agent title company received to the seller yet. When my trust fund, when my trust fund has received the loan funds, if they have a loan, and received the cash to close, and all of the documents, that is a closing. That is a closing. So what I do in practice is I email everyone, hey, congratulations, we have a closing. I have received the cash to close in this amount. I have received the loan funds in this amount. And here's a copy of the closing statement and confirmation that I have received the loan package. And I add, as an attachment to my email notification, the incoming wire transfers of the cash to close and the loan funds. That is enough. The listing agent and the seller cannot hold the keys any longer. There is a closing. So that's very clear. And whether you like it or not, what I appreciate is that we finally have an answer, because there was always dispute about that. So that's how I've handled it. I think it's cleared up a lot of things. Believe it or not, I had a closing last week with a very, fancy law firm. They were big real estate lawyers, and the managing partner got involved, and he didn't know that. I had to get the legal hotline involved and everything from the Florida Association. So you'll be surprised. I think people get comfortable in knowing what they've been practicing for so long that they don't really take the time to read up. So I think that's a huge change in our industry and in our everyday closing. So I appreciate that. So moving on, just this is another item, especially here relevant to our market, is that now paragraph 6, which talks about, is this subject to a lease or not? Check here, check there if it's not. Okay, it doesn't say lease. Now it says occupancy and possession. Why? Well, Airbnbs, VRBOs, programs like that, we've realized that we're no longer just seeing 1-year leases. Okay, we're seeing short-term rentals. So here it's important to speak, again, listing agent, speak to your seller. Maybe you don't have a tenant, maybe you're not renting it out, but did you rent it out for Ultra for 3 days, the Super Bowl? I don't know. That is what's considered occupancy and possession. And not only will you have to disclose that on the contract, but you're gonna have to add a rider to it as to what type of occupancy and possession exactly is going on here. If it's a short-term rental, well then the buyer is gonna have an opportunity to review the agreement that you have, the seller has with, Airbnb, VRBO, whatever company, property management company they're using. So I think that is relevant, and I've seen it happen in closings already since November. Okay, so that's why they did that there. Paragraph 7, it's a very short paragraph. I see agents leave this blank all the time because they just think, oh, either they don't know or they brush it over because they don't think it's an important term. But now it is, and this is important for the buyer's agent. What they said here in paragraph 7, what they clarified is that if you do not check off any box there, it will automatically be unassignable. What does that mean? That means that, for example, and this happens a lot, I have an individual buyer, Jose Gonzalez is the buyer, but Jose Gonzalez between contract and closing is gonna create an LLC. And he's gonna put himself and maybe another member, maybe just him. If the seller really wants to, the seller and the seller's attorney could say, hey, sorry, Jose Gonzalez as an individual has to close because you didn't check off that it's assignable. So I think that's important to know. So the next big, huge one that we could have a whole other training just on is paragraph 8, which is financing. What I'm going to say here is that the most important thing to understand, bless you, Sarai, the most important thing to understand is that paragraph 8 put the burden on the lender to have what's called a sufficient or adequate appraisal or evaluation before the expiration of the loan approval period. Why is that important? It's important because the lenders in general were issuing pre-approval letters or letters even from underwriting, saying that one of the conditions was subject to appraisal, subject to the value coming in. And the day before closing, and it was happening a lot, the appraisal comes in short. And now the buyer is scrambling for more cash, or the buyer wants to cancel. The seller says, it's the day before closing. What do you mean? You passed your inspection. You got the approval letter. We're past loan expiration, loan approval expiration. So what FREC and the committee tried to do was put more responsibility on the lender to get that value, making their approval more thorough and more complete. So what I thought was going to happen was that in real life, we were just going to have to be constantly doing loan approval extensions because the appraisal wasn't going to be ready in time. I haven't run into that yet, thankfully, and the values and the appraisals have been coming in on time. But that's a big addition that they did, that the lender has to have a sufficient value or appraisal of the property before or on the date of expiration of loan approval. So what does that mean in real life, agents? When the lender issues I don't know if it's either a loan commitment or a loan approval, whatever they word it, right? They use their own language sometimes. If you see there subject to or pending review, subject per the review of, like basically means that they still have to review something, and you see the word appraisal or value, that is not an approval. Buyer's agent and listing agents need to know this, and it's your job to protect your client, and my job as well, to say, hey, lender, sorry, but you're gonna have to be a little more clear. What, do we need an extension? We can't have this value appraisal situation lingering, because then it doesn't protect the buyer and the seller either, because the seller then wastes time. But the point is that this paragraph has put the burden on the lender. Paragraph 8, adding this about the appraisal, has nothing to do with the appraisal contingency. Everybody mixes that up. Remember that what they added to paragraph 8, putting the burden of the value and the appraisal on the lender, is for the lender. It's for the timing of the entire closing. Whereas the appraisal contingency is just for the buyer, meaning the buyer wants to protect himself in saying, if the value does not come in to support this loan, buyer can cancel, or seller reduces the price. That is the appraisal rider or appraisal contingency rider, which has nothing to do with what paragraph 8 is adding here. Paragraph 8 is just how do I say, adding that burden to the lender so that the lender can't toss their hands up in this air and say, oh, sorry, yeah, we gave you an approval, but we needed the valuation to come in. Now that we're just wanting the lender to speed things up a little bit, okay? Something else related to this paragraph, which I think is very important because I see this every day in practice. New agents, old agents, experienced agents, we all do this. What the goal of a lot of these new additions or revisions to the contract, the goal is to improve communication, improve it. So there's something here that if on the last day of the loan approval period, let's just say the buyer's agent, this is something that happened, I'm going through this right now. The buyer's agent wrote an email, not the title company, the buyer's agent wrote an email on the last day of the loan approval period saying, we need an extension on the loan approval period. On the last day, not we've been approved, we're denied, an answer. It was, we're asking for an extension. Well, the seller didn't get back to them on time. I guess the buyer's agent thought that was sufficient to hold or preserve the right to extend the loan approval period. This is where I wasn't even sure. So I called the legal advisors for that had to do with this contract. And I think it's very important that as the agent or as the lender, you must provide a status, a clear status. Asking for an extension is not a status. Saying we need more time is not a status. So in real life, what does this look like? If by the last day of the loan approval period, you don't have what you need from the lender as far as accepted or approved or denied, you send out an extension or you say, hey, this is denied, or we haven't heard from the lender, but there needs to be clear communication as to what the update is on the loan. And that's on the lender and that's on the title company, in my opinion, to really get that detail in. But according to, if this was ever to be disputed or we go to mediation, the buyer is going to be found in default. And I'm actually representing the seller only in this transaction. And we may very well be in that boat when it comes to closing because he's still relying on getting a loan to close. So I don't know, follow up with me in about a week and a half to 2 weeks to see how that's going. On that same note, the buyer not providing an update, just asking for more time, it automatically turned into a cash transaction because the buyer did not preserve that financing extension. So now we're in a cash transaction. That doesn't mean that the buyer can't get a loan. That means that all of the protections that the buyer has under paragraph 8, when, like, for example, let's just say we're at closing day and everything's signed, loan package, okay, whatever, and the loan funds have not hit my account, let's say, and the buyer says, oh, we have a closing, I just haven't gotten the loan funds. It doesn't matter. We're in a cash transaction. This isn't based on me getting loan funds. This isn't contingent on me getting loan funds. So I think that's very important when you're on the buyer side. Paragraph 8 is very delicate now, and you need the lender to communicate. I like to say that they did this because lenders, this has happened to me in transactions, buyers agents, title companies, and lenders would like ghost us, like ghost the seller side, like the 1 or 2 days of the deadline. And then like, a couple days later, we're like, oh no, here's our approval, 3 days later. No, if the buyer does not communicate the status, accepted or denied, automatically a cash transaction. So that's a biggie to protect your buyer. The buyer might think, oh, I'm out of contract, no big deal. I don't have to do an executed cancellation release. They're still on the hook. And again, paragraph 8 is a biggie. There's a lot of other changes, but I think those are the most important real life ones to explain to your buyer when you're representing a buyer. All right, so we're gonna be moving on to paragraph 9, which basically just distributes the cost of each side, buyer and seller. All that they added really was that the seller, if you're a foreign seller and there is FERPTA work, the foreign tax withholding that has to be done. Now they've clarified that the seller has to pay for it. They're the foreign one. They got to get their CPA and all of that to prepare the documents. That's all. I never ran into that personally, that the seller didn't want to pay for it and thought it was the buyers. But anyway, seller has to pay. That's all that they really did to do that. Something that they added there that affects me as a title agent is that, surveys, property surveys are usually out of pocket for title companies. And now added that we can't order a survey last minute, at least 5 days, should be longer because surveys are taking a little longer now. At least 5 days before the closing date, I'm supposed to be providing a survey. I can't, just like the loan appraisal or evaluation, they're trying to get the things that usually hold up closings. They're trying to get us to do it earlier. So that affected me because now I order the survey a lot earlier than we used to. Let's see here. Time. Okay, I just wanted to go over this. When calendar days are through midnight. So a buyer with this contract can technically sign at 11:45 p.m. on, March 22nd today and be in compliance with the closing date, but the funds obviously will be the next morning. The holidays, when you're dealing with a contract that runs on calendar days, weekends and holidays, all days are included. I had a recent transaction where someone tried to say that President's Day, which was back in February, gave him an extra day. And just so you know, I even doubt myself sometimes, so I always double check. And I went back to the Florida Legal Committee, and they said, no, calendar days are calendar days, and holidays and weekends are included. When do you get the extra day in a calendar day transaction? When the deadline, let's just say closing day ends on December 25th. You can't close on December 25th because banks are closed. It's a national holiday. So it automatically gets pushed to December 26th for something like a closing date. But where let's just say, I think President's Day was February 20 something. And 2 days later was your deadline for a closing on March 1st. March 1st, you had to close. It's not, it's March 2nd because Monday was a holiday. No, it's March 1st. So I want to be clear, that whole holiday rule in a ASIS calendar day transaction is only when the deadline falls on a holiday, Saturday, or Sunday. I want to clear that up because I know people bicker about that all the time. Something just a sign of the times is force majeure. They added not pandemics only. They added pandemics, they added government shutdowns, government mandates, government closures. So they've extended this to cover more natural disasters out of the control of the parties to a contract. So in addition to those revisions that, again, these are what I like to call the big ticket items that lead us to get to a place where we're threatening, cost of mediation, attorney's fees, default, withholding the deposit, things like that. That's what I wanted to point out today. Please don't think that was like an all-inclusive, deep explanation of the contract. Those to me are the ones that affect us and you, the agents, on a day-to-day basis. So in addition to some revisions that they did to the contract, they added 2 new riders. Riders mean that basically they are annexed to the contract. It is a form of further communication and further disclosure to both sides. And riders are part of the contract. What does that mean? If on April 1st, you have a contract and then there's I should have put this rider. Now, April 6th, a rider is circulated. Unfortunately, now we have an April 6th effective date because it's part of the contract. So let's go over these riders to the as-is that were added. Rider DD now is the seasonal and vacation rental rider. What does that mean? When you're taking on a listing and the seller has one of these Airbnb, VRBO, they lease it to someone for a week, next year, you have to add on this rider. And the rider, when you look at it, will give further information, which is whether or not is there a contract. If so, you must provide it for the buyer to review, because if the buyer doesn't like the contract terms, they could cancel it. Who's managing the property? Is there a property management contract? Also provide that to the buyer. So that rider is now issued, if you will, to further educate and notify all the parties. The second rider that was added is the PACE disclosure. So PACE is that, well, you've heard of Y-Green. Y-Green and PACE is used synonymously. And I have had to deal with this in litigation, where the seller did all of these what's called environmental efficient improvements, and you have the opportunity to finance it as the owner of a home through your property taxes. So there was a dispute a lot between buyers and sellers, whether is this considered a like part of my property tax bill? Is it a special assessment, or is it a lien? Why does this matter? It matters because buyers, usually are getting a loan. And when their lender is going to risk a significant amount of money for you to purchase this property, they want to be in what's called the first lien position. They want to be the only lien on the property. They don't want any other recorded debts or recorded financing agreements. And that's what this PACE Y-Green is. You are financing. And they finally clarified that, because sellers, of course, especially if they've done impact windows, solar panels, they redid their AC. We're talking like $50,000, $40,000 that people were financing through their property taxes. And now a seller is relying on their proceeds to go reinvest or buy something else. And they're out of pocket, surprisingly, right? Because they didn't know that they were gonna have to pay it in full before they sold. So it was causing a big issue. And then the buyer side would always argue, this is a lien. It's like a mortgage payoff. You have to request a payoff and pay it off. And the seller is saying, no, this is an assessment. Therefore, buyer pays until closing. After closing, the seller takes, seller pays until closing, and then after closing, the buyer takes over. So I actually went to mediation about this. And there are lawsuits all over the country against PACE, because PACE, what they're alleging is that the PACE program misrepresented how this was going to get paid. So this program started in California. It's been in some states. It's definitely here in Florida. A lot of people took advantage of it. And now the committee advising on the contract decided that this should be a disclosure, and this is considered a lien for the purpose of seller has to pay it off or clear it. Unless, if it's agreed and it's a cash transaction, the buyer says, hey, I'm okay, I'll take over the financing, the payments after closing. So those are the things or the items that they added. People are getting confused with the mold, like a mold and septic tank rider. That's for the non-as-is residential contract. I barely have seen that one in practice. Again, I went over the as-is today. So someone is asking some questions over here. That's my broad summary for everyone asking me, where is this? Where can I find this information? I did share documents. They're in depth. I think they're very valuable if you actually take the time to read it, and it explains the intention and the logic behind the new language. I shared that with Sarai and Jenine a few hours ago for the purpose of distributing to all of you. And it's good if you have any questions or doubts, it's thoroughly explained there. And if you need further clarification, I'd be happy to assist. So I'm gonna read over the chat to see if there's anything I could address here, and I can also open it up for some questions if you'd like, Sarai.
Yes, actually, you know what I was thinking? I was thinking of actually sharing my screen and showing them the contract while we go through the questions. Would that be okay with you? So let me see. I don't hear you.
Because I was muted.
Oh, okay.
Mhm.
I'm going to share my screen. Let me see if I can, how do I do that?
Well, I'll start with the first kind of issue slash the appraisal addendum. Yeah, Janine, it does help the buyer with that issue, but the appraisal, remember in this market, if you check off appraisal, that it depends on the appraisal, the seller will probably not accept your offer. So that's what we've been running into a lot. So what I try to tell buyers is, what does that mean? That means that if your property doesn't appraise, it's going to be more out of pocket for you at closing. Can you handle that? That's a realistic question. That's just, hey, can you handle it? Do you have extra cash to close? If not, then it's risky.
What I'm sorry to interrupt. What I'm finding is that in those circumstances where we do have buyers that don't have a lot out of pocket, we do add the appraisal addendum, and
Mhm.
that will prevent them from falling within the loan approval period. Because you can have the appraisal done up to 10 days prior to closing. And
Mhm.
if you're past your loan approval and the property doesn't appraise, the buyer is still protected that way.
Absolutely, it's a further safeguard. So that's great that you do that. A lot of people don't. Like the majority. So that's really great that you do that. And I explain it all the time right in the inception of the contract. I like having that discussion with the buyers and the buyer's agents. So that's great.
Let me see if I can share.
I do have another question. As far as the Y-green taxes, where is that found? Is that a special addendum as well?
It's a rider. Yeah, so I get an addendum rider. This is just my personal vocabulary. An addendum, I always think of like an addendum to the contract where
Right.
the realtor is going to be typing in, terms or whatever. A
In addition to.
rider, yeah, rider is already done. Like it's part of what I call disclosure, notifying everyone on this contract that this information, this situation, this term exists.
But which is the rider for that Y-green?
I'm going to pull it up. Can I pull it up?
It's not going to be called Y-green. It's not going to be called Y-green. It's EE, and it's called the PACE disclosure.
Okay, I'm going to look it up just to see if I can.
Perfect.
It's on the, yep, there you go. Go to forms, and it's EE. It's the last and latest rider.
So I put EE.
PACE.
Will it show up if I just put EE? Well,
I'm not sure. Try it.
Okay. Just so that we could show them. Let me put PACE. Could be the internet.
It should come up with PACE. You just have to close your box and do it again because it's not giving you a little green button on the bottom.
Okay, let me try that again. PACE. There we go. Oh, it's this one, EE.
Mm-hmm.
So this is the rider that Cristina was talking about.
Yeah.
And
So what does that do? That discloses to the buyer that there is one of these financing agreements on the property, and unless otherwise agreed to, it's considered a lien. It needs to be closed, paid off before closing.
I used the PACE, so I know exactly. I used it to do
It's a great opportunity. What happens at IA is that 5 years ago, 6 years ago, when people started using this, you thought you were going to be in your house for 15 years, and then the market spiked up and sellers were like, oh, shoot, let me take advantage and sell my property. And, there were only owners for 4 years or something, right? Let's just say. So in such a short amount of time, you didn't make a dent on the amount that you owed. So you were pissed off. It's a great program, I think, if this is where you're going to be for a very long time. It's just when you go to sell, it's a little rude surprise. So that's what.
But it has to get paid at closing, not before closing.
Sorry, that's what I mean. As if it's a payoff. When someone has a mortgage and you pay it off at closing, you ask for a payoff from I've had to call them. I forgot the name of the office. I don't know, the
Why
financing,
green?
state of Florida.
Something green.
Yeah, but yeah, wire green is the nickname. It's like what we call it, but the
Okay.
broad how to say category is PACE, because it's like agreement. So it says it there in the writer, but listing agents, you know where else you could find if your property has it? Because I have literally seen sellers deny that they did wire green. They're like, what are you talking about? They don't realize that they financed these improvements. They're like, no, I got impact windows and solar panels and I paid for it. No, you're paying for it as a lien. So sellers themselves don't even know they have it. You could actually look at it at the property tax bill. Go on the property tax bill and you're gonna see it on the bottom there, that section of like all those extra assessments that local communities have, you're gonna see it there. And guess what, guys? If you don't disclose that there's a wire green or PACE and nobody looked at the tax bill, agents can be held liable for non-disclosure, because technically, like, that's part of an agent's due diligence when you're taking on a listing, going on public record. It's public record. So I think that's very important.
I wanted to kind of clarify about paragraph 8. I know we keep circling back there, but okay. So if in paragraph 8, regarding the appraisal, if we do not have an appraisal contingency, then after the loan approval period finishes, the transaction becomes cash?
Only if the lender did not provide
An
a
update.
valid approval and/or the buyer side did not provide any update. By the end of the loan, the last day of loan approval period, if there is no approved or denied, then and the buyer did not cancel the contract, it goes on as a cash transaction. So to review, in real life, it's the last day. You, the buyer's agent, are hounding your lender. They're either nowhere to be found, or they say it's still in underwriting, it's still here, it's being reviewed, et cetera, et cetera. And there is no approval and there is no denial, either or.
Sure.
Your buyer should cancel if there is no appraisal contingency, or go on as a cash offer, or can still get financing if he feels confident that he'll get the loan funds.
Got it.
So let me see here, because one of the documents I sent you, Sarai, it is
The red one, the one that's
no, it's titled Excerpts and Explanation of Significant Changes to the 21 Florida Realtors, blah, blah, blah. And on page,
let me take a look at it.
on page 4, it goes into all the nuances of what that means. It's so much so that 1, 2, 3, 4, 5 pages.
This one?
Nope, that's the contract.
Sorry.
It's okay.
To the last one, the summary.
There you go. So go to page 3.
This is page.
Go down because we're going to paragraph 8.
Okay, here we go.
Sorry. There you go. The next 5 pages talk about all of the nuances on the financing.
And guys, you have this in your email. Jenine
Yes.
sent it out.
I have a question.
Yes, Sylvia? Is it Sylvia that's asking?
Yes. On the financing side, I'm circling back. If the appraisal is not yet done within that period, is either we cancel or we send an extension for the loan period, right?
Yes. But guess what? You could send a request for an extension. But what if the seller doesn't agree to it or doesn't sign it in time because they're out of town or something? And now we're
right. But we have the option to do an extension on that.
Yeah, of course, yes.
And
the
then
option,
we'll,
that doesn't, it's not for sure. And that's what's happening in the closing that I'm doing right now. That the buyer is still pursuing the loan. He just did not get the approval or denial on the last day. He's still relying on that loan. But what that means is on closing day, if I don't get the loan, or excuse me, if the title company doesn't get the loan funds, my seller could technically say, too bad. You know, you're deep.
no, I have 2 deals right now that the appraisal were ordered the first week. And next week we're closing and we just did it.
Okay, so the report,
appraisal.
but when the report did, what about the loan approval period? When does that expire?
It's already expired. I'm the listing agent for both.
And there's
So-
no contingency or appraisal.
The only thing that we have done is we have signed the extension. Because, you know, when you have the listing and it's the way you talk to the client, you know, it's not fair for the buyer, you know, to not to extend it because it's not any fault of their own.
Yeah, I know. What I like, trust me, I'm the compassionate side of me understands. The contract side of me is
No, of course,
appraisal. The appraiser, your lender, is not a party to the contract. There's only 2 people on that contract. There's a seller and a buyer.
Exactly.
Unfortunately. And that's part of our risk as buyers in investing, right? In buying our house. And there's a risk. We forget that this is risk. There's risk here. And
Everything.
actually, exactly what I'm talking about. Go into depth. It goes into depth into the logic and the explanation. And it is on 1, 2, 3, 4, 5. It's on page 5 and 6. Talking about the communication, what's an approval, what should the buyer do if he hasn't gotten a valid approval. Let me see, keep scrolling. Okay, here we go. Wait. That I stop.
Sorry.
So you're gonna see there, it says the buyer has a duty to keep the seller informed. The previous version of this did not require the seller to make a written request. Then it's gonna go to, if within the loan approval period, buyer obtains loan approval, buyer shall notify seller of same in writing prior to the expiration of the loan approval period. Or if the buyer is unable to obtain loan approval, but buyer is satisfied with the buyer's ability to obtain loan approval and proceed to closing, buyer shall deliver written notice to the seller confirming same. Meaning that's where I said that in my case, the buyer did not get his approval yet, but he felt confident that he could still get financed and he moved on. But without the protections of all the little protections that you get with financing. So scroll down a little more. Here we go. Also note that the new language of the new contract specifies that a buyer who does not obtain loan approval within the loan period may remain in the transaction under the following circumstances. The buyer is satisfied with the ability of the lender to fund. That's what we just talked about. The buyer has to give written notice that he still is going to move forward with it. So it's giving very specific instructions on how to communicate, which I think is important for you guys who are doing this every day. Okay. The next page on the top, if the buyer is unable to obtain loan approval or cannot timely meet the terms of loan approval, then he can basically, upon delivering written notice of termination to the seller before expiration of the loan approval period, he can get his deposit back. So again, it's putting the burden on the buyer's side to constantly be communicating. Scroll down, I'm going quickly, but it says if buyer fails to timely deliver any written notice, just ghost everybody. Just the buyer side is not communicating. The seller can elect to terminate the contract in 3 days after the expiration of the loan period, or if the seller doesn't elect to cancel it in those 3 days right after the expiration of that period, it's the cash transaction. It's what I was saying about the cash transaction.
Wow.
Yeah.
So I have a question regarding notifying the listing agent. If we do a good job and we notify the listing agent of the process and we have loan approval, but the loan approval has conditions on it, and then those conditions after loan approval period, something happens and they're not met, is the buyer still protected under the financing?
Yes, because the conditions have to have nothing to do with value or appraisal. I don't know if I'm
Right, let's suppose they lose their job, or they can't provide a certain bank statement, or the bank statement doesn't meet something that the lender needs,
If they
and the loan is
exercise-
denied afterwards.
If they exercised with good faith and due diligence in providing everything and they got denied after the loan approval, and after they got their approval, that was, by the way, given a copy of it was given to seller side, because buyers now have to do that upon written requests from a seller. The buyer does have to give the approval letter showing the conditions, unless if there's something, this happened to me in real life. The buyer says, absolutely not, that has my personal information. Okay, well, we per the lawyers that guide the contract, we just have to block that out. So they would be protected. Why? Because they exercised good faith and due diligence. This was something like that they already got approval, they relied on it, they provided notice of it, and now there's an issue with underwriting. So, and if they cooperated with all of the obligations under paragraph 8 and all the deadlines, then they should be protected. Something about communication, by the way, which again, I think it's funny. It's a reflection of us, the state of Florida, which we're always like ground zero for all of the new things that come up. Texting, WhatsApp is not notification.
Right, it has to be email.
Email. Yes, and I'm laughing because I get WhatsApps all the time.
I tell all my agents, or I mean, they're my witness, that I tell them all the time, text or WhatsApp or anything like that is not admissible. You always have to follow up with an email.
And
So
agents
just
would
go
get
back.
upset. Agents would get upset with me because they're like, oh, she's a lawyer, she's just being annoying and asking for emails. And now I could back it up with this and say, no, the electronic media is not is notice. It has to be written, either US mail written or email.
Right, so everything, always follow it up with as per our conversation, and just send out an email, even if the other agent gets annoyed at you, but just do it anyway.
Absolutely.
Just a quick clarification on the riders, the one that you mentioned for the seasonal and vacation ones. So
You want to pull that one up?
Hmm?
You want to pull that one up?
Sure.
Because I think it's interesting. It has like 2 parts to it.
Oh my gosh, I have like every screen open. Okay. Is it under a specific? Let me just put writer and see what comes up.
That's DD. It's the one right before pay.
Oh, look at, okay.
DD, as in dog.
Okay.
And it's called seasonal / vacation.
Let me put seasonal and see if it comes up as seasonal. So this rider, oh, it's this one?
Mhm.
It's only in the event that you sell the property with the condition that it's going to, you're selling it already as an Airbnb or Verbo or whatever, and you're just transferring that?
This is if that it's subject to some sort of seasonal or vacation occupancy after closing.
Okay.
By the way, this has nothing to do with how it's zoned, if the local city approves it or not. No, this is that your particular seller and your particular property is under contract already for some time in the future.
In the future. Okay.
You're not designating it. You're not saying, this is a great vacation seasonal opportunity. No, you're basically just saying, my seller, we are already in a contract for a future after closing seasonal vacation rental.
Okay.
Why you need that?
Who's, I don't know.
Sylvia, do you have a question? Because your hand is up, or was that from before?
I think that was from
That
before.
was from before. That was from before.
And Monica, you were asking why do we need this? Was it Monica? That's the only one that's unmuted. Monica?
And Janine, I'm reading through the questions because we should wrap up. It's 11:52. I don't want to bore you guys to death, but Janine, you're right. So the listing agent would be liable for something that can easily be looked up, like me, even as a title company or the agent, right? Because by the time the contracts get to me, they're already executed. It's a legal document. If the agent could have just looked on the public records for any
No se puede abrir mucho.
then it's non-disclosure by the agent. I wanted to share something that has nothing to do with this new contract, but now that you
Me
guys
debe un
are
tornillo más gordo, papi, para
Oh,
sacarlo.
hold on. I don't know how to mute this person.
you can mute all or something like that except me.
How did I do it before?
Okay, well, I'll continue.
Okay.
I have one situation that's being litigated right now. Apparently, I didn't even know this. There's an area around Doral that does like what's called fracking or something, and there's like explosion sounds.
That happens here
Often.
in Miami Lakes.
That's where it is. Okay. The buyer is suing the listing agent and the seller for not disclosing that it was in, I don't know, whatever. What is it called? Is it frack? I don't know. I'm calling it fracking, but like it's
I don't know. We call them mini earthquakes.
Earthquakes, yeah.
So I did not get involved, but I was involved in a transaction. And it's one of those things that's gonna have to be litigated. Like, could the listing agent and seller, well, the seller definitely knows, right? I mean, he's living in the property. If he feels these mini earthquakes. Like when I sold a house, my former house ages ago was right in front of you can't see it, but a train track. And the train went by in the morning and in the late afternoon. And I had to disclose that. I mean, that's a big issue. So I don't know what's happening in that case. But why? The listing agent was freaking out. She's like, I didn't know that. Where could I have found that? I don't think the listing agent should be liable. However, if I'm on the buyer side, I'm saying, you're the listing agent, you're supposed to know the area, that's part of your job. I don't know that. We'll see what happens there. Now, another one.
Real quick, but I don't think there's any law that states that you have to disclose that there's these mini explosions going on. Just like we don't have to disclose if someone passed away in the house.
Yeah.
Oh yeah, I remember Christina's talked about that too.
So why do we have to disclose?
California, New York, you have to disclose if there was a murder within the last 2 years.
And in Florida, you don't have to disclose a murder?
I mean, not that I know of up until today. So yeah, the mini earthquakes, if that's not in the law, it's not in the law, but I found that, I learned that.
Well, we're selling a lot here in Miami Lakes where we have that issue. So if that's something that has to be disclosed, we need
PSN.
We need to add that into our contracts then.
Or the listing, the description, or I don't know, the broker.
Okay, perfect. So I wanted to share another situation that I do know the answer to. So I have an agent that was representing the buyer, an investor buyer, meaning the investor is probably in just a few months going to sell again. He purchases the property. There are survey problems, boundary problems, encroachments, etc. The title company, well, first of all, the title company is at fault here. The title company did not circulate copies of the surveys nor notified them or anything like that about the survey. So the buyer didn't even have an opportunity to look at the survey. So when the buyer past closing, the buyer goes to check on the property, he already has it relisted. The neighbor says, hey, I never said anything before because it was so many years and the man was an elderly. This is like in the area, like right up, like north of the Gables. It's in like Southwest 3rd Street and like Douglas area. There's encroachments everywhere. And when he goes to sell, now the neighbor is doing a lawsuit for basically, we pay our property taxes based on the amount. One of the factors on our property tax bill is the amount of land that we have. And the neighbor said, well, you have been, your property is encroaching on mine. And it was like a significant structure that was encroaching. What I'm getting to is that the same agent that handled the purchase for her buyer and then relisted it and is selling it, and she did not put it on the MLS or disclose it as, hey, there's an encroachment here that affects the property boundary or property value, the agent is liable. And I sought verification of that from the legal committee that advises the Florida Association of Realtors. I thought that was very interesting because
That seems, yeah, that seems crazy to me that an agent is liable for a property boundary when they're not even responsible for taking the property boundary. That's up to the surveyor.
but she knew about it. She knew of it because when
Well, that's
her buyer after closing, remember, we're between when she's her buyer investor now
They
knows
bought
about it, complains
with-
to her and says, hey, my agent, how come the title company never said this? Now I have this problem. Now they know, they go to sell the property, and per what I was explained is on the MLS, even it should be, you know, property has encroachments or something like that.
And the broker
I think
remarks
it's-
from
It's about knowledge. It's not, you know, whose job it is. I agree. I think it's a little intrusive, but I found that
Well,
surprising.
I'm aware if the agent is aware of a defect in the property, they have to disclose it. If they're not aware, I mean, they're not aware. But if,
Right.
like, for example, it has a foundation problem, they have to disclose the property has a foundation problem. They can't just stay silent on it. And
Yeah.
there's no specific addendum that says that, but I would imagine the same thing falls with.
It goes to the
encroachments.
general non-disclosure, disclosure issue. Disclose, disclose, disclose. That's what contractually and legally they want agents to do.
So which goes back to either disclosing it on the MLS or making sure you have email documentation that you inform the other party of this issue.
Yeah.
Correct?
Jenine, we should take some time to like really get an answer about the mini earthquakes.
Yeah, I think that's a big issue because we're selling a lot of properties here in Miami Lakes, Palm Springs
PSN.
North, Doral, where all of that area has that issue. Even Miramar, Pembroke Pines,
Yes.
all of that has that same issue. So
Like how many times a day? Or is it even?
it's twice, it could be up to twice a day, but usually around the 11 a.m., 11:15, you'll feel it. Like in our, especially in the office, like if you're in the office at 11:15, you will feel the building tremble. So it's a little scary.
Well, I mean, I hope, I know you guys have probably been using the contract for a while already. Really quickly, any issues, practical issues that you guys have faced, conflicts that you guys have faced that I didn't touch on today?
I really don't think so because I've pretty much trained and those that I haven't trained have been with us for a long time and they know, and we go over these same things all the time. So I'm a very involved broker. A lot of my agents, they know that they can just pick up the phone and call me and we make sure that everybody's protected all the time. So fortunately, we haven't had any lawsuits or any problems with the contract at all. Thank God.
Great. So I did share my contact info in the beginning of about an hour ago in this chat. If not, I'll put it in again, but I'm Jenine, you know, through Jenine or directly to me. If anyone on the Zoom has a specific question, I'd be happy to help. But thank you everybody for listening to me. I try to make a boring contract somewhat relatable. And it's, you know, it'd be great that if some of this information helped keep us out of trouble, then I did my job.
Thank you so much.
Thank you very much, Cristina. We really appreciate
Thank
you
you,
doing this for
ladies,
us.
Sarai and Jenine for hosting, and I'll do it again. We could do one just on paragraph 8. I mean,
Yeah, that one's very important, and I agree.
all right, everybody. So I'm gonna mute here and sign off, and it's a wrap, I guess. Thanks, everybody.
Thank you.
Have a good day.
You too, thank you.
Talk to you soon. Bye-bye.
Bye. I'm not sure how to do this. Let me stop recording first. But I have to stop recording.